Welcome back to Morning Barbados, and this morning on our Lawyer on the Line segment, we have been looking at the Casey Anthony trial in the US. It captivated the world, and we've been looking at aspects of that trial. We've looked at evidence versus innocence, the
proof beyond reasonable doubt.
Exactly, that sort of thing. And usually in American cases, the time that the jurors take is also a big thing.
Topic of discussion, yeah.
It took 11 hours. That to me is a long time, but apparently that was short enough for people to suggest that she was going to be acquitted.
Well, the American system, and I speak generally because different states have different laws, but generally in America the jury is allowed to deliberate so long as they are not indicating that they can't to reach a conclusion. In Barbados there's a time limit. In most of the Caribbean jurisdictions there is a time limit. There's more than one time. It used to be 3 hours, it's now 5. After an hour, but it is not, well, it doesn't scare me as defense. It's certainly because as the time whittles away, you get a certain sense that if a jury cannot reach a conclusion, then
so we've had a trial for 5 days, maybe 10 days, and you only have 3 hours to decide on.
No, you see, this is where the American system probably has the advantage, because if they really were to scrutinize 31 days of evidence, it was not going to take them 5 hours. In Barbados, though, it is a recent phenomenon for trials to take really long.
Okay.
My first 3-week trial, I thought, was really long, and then along came the case that I mentioned just now, the Queen and Rambaran and others. I speak under correction, but I think that was more like 4 months that case took. But of course, there were some days in there that were lost days, but for the most part, there was evidence-led every day. A lot of that was out of the scrutiny of the jury. There were a lot of submissions in that case, and submissions in Barbados are usually what make a case go on that long. The reason for the time limit is that you want to focus the jury, and if it is that you have been in the presence of the evidence, and not everything that is led in the court is going to be critical to your decision making, and if in 5 hours the 9 of you or the 12 of you, if it is a capital case, cannot have a meeting of the minds, if after an hour or somewhere around an hour, the judge can call you back and say, look, do you need me to give you any more guidance? The jury can ask the court for more guidance. But if it is looking like there's never going to be any agreement, and there's certain, where it is not a capital case where you need unanimity in order to get the death penalty here in Barbados, where there's a case where a majority verdict can do, but obviously you don't even have that. Then it probably is right that you don't prolong it, because then you might have a situation where one juror can exercise influence over another juror in order to change their mind. So perhaps somewhere between the two, because there will be some cases where 5 hours is not likely to be enough, but it is not a hard and fast rule too. They have gone a little over, and some have been, most cases in Barbados decided long before that 5-hour period in any event.
All right, we'd like to invite Dennis onto the program. Good morning, Dennis. You're live on air.
Yes, hello, good morning,
That's
everyone.
not Dennis, that's Sherry-Ann, I would imagine.
Good morning.
Hi, good morning, everyone. Okay, my question to the lawyer is, I'm renting a house, and the landlord told me that he wanted the house, but he's saying that I still have to pay him the money because I'm in the house and that I have to leave. I would like to know, isn't there a law or something that at least gives me at least 3 months or 2 months so that I can gather enough money so I can leave his house? Because it's not like if there are houses out there that I can rent, because I'm paying $700. It's not like if there are houses out there that I can rent that that I would say, well, okay, I would give you your money, then go and get another one, because you know houses is very hard to get. So I would like to know if there's something legal that I can at least stop him from like coming to take my things out of the house and throw them out or whatever. Can you please explain that to me? Thank you.
Yes, as succinctly as I can, because there is a process and a formula. First thing is, he can't just tell you to leave. It has to be in writing, what we call a notice to quit. And because it is a residential tenancy, he also has to give you a clear calendar month's notice in order to leave. If he's already done all of that and the month has expired, then he's not entitled to collect rent anymore. If he collects rent after the period of notice to quit, he's actually endorsed the continuation of your tenancy. After the notice to quit, though, if he is following the correct procedure, after the notice to quit has expired, he files, first of all, he serves first of all on you another notice, which is of his intention to apply to the court to have you put out. And then, I speak in a correction, but I believe the required time frame for that is 14 days. And then he files a complaint in the magistrate's court to have you evicted. It is at that point that the court, on your behalf, will give you a firm date on which to leave, and on his behalf will allow him to collect the equivalent of the rent for your use and occupation of the property until you actually move out. So he does still get his money's worth. It's just not called rent anymore. That is the general process. It is with the understanding that residential tenancies are hard to come by, and in recent times are also more expensive than they were before. However, since the relationship obviously is broken down to the extent that he is not willing to give you time to look, you should be enforcing this procedure. If you don't have a notice to quit, you can insist that you can pay your rent. So long as he's taking it, you can pay it, because that does extend your tenancy. But on his behalf, he needs to follow a particular procedure, and the magistrate will be the one who tells you the date that you absolutely have to leave by.
I'm not sure if Dennis is still on the line. Is he? Dennis? Good morning, Dennis.
I'm not hearing you.
Sherian? Dennis? Oh, no. I would like you, before we go on, to just repeat these steps on that, just so that, you know, we get it clearly. The first thing is you have to get a
notice to quit.
A letter.
It is in writing.
Yeah.
It is in writing. It is a notice to quit. It has to give you at least 1 calendar month's notice, and I say at least because most people have a month-to-month tenancy, and it would be a calendar month's notice. But if you pay by the quarter, then it has to be a quarter's notice. If you pay half a year, it has to be a year's notice, and you would get the idea. It follows that pattern. Once the date on the notice expires, the second step is the notice to you of his intention to apply to the magistrate to recover the possession of the property. And once that time limit has expired, he actually files in the magistrate's court a complaint against you that he has asked for his property and has not got it back. The magistrate's court then will give you a date. When you come, you state your case for why you can't move out of his property or why you haven't moved out as yet, and the magistrate will give a date that is supposed to be your fixed exit date.
And can the who does evictions? Like when it's all going through the court and everything, you've been given the time by the magistrate and you haven't, who does the eviction? The landlord can come and tear the door off and throw your stuff outside,
well,
or these court marshals? Or?
The court marshals do the eviction if you follow the process of the law. The difficulty, though, I'm speaking very slowly and carefully here, because there are some landlords who do take the doors and the windows off.
That, yeah.
They have not damaged property, it's theirs in any event, so they haven't done anything wrong. However, they have abused a system. There's a system in place which protects them, they get their money's worth, and which protects the tenants. They get to look for somewhere else to be. So it is the best process that you could want, because it is looking at the needs of both parties. So long as the person is still in your house, landlord, the court is going to award you the same amount that you were charging for rent, so you don't lose out. And tenant, you do actually have to look for some place to be. It doesn't help that you go to the media and say you got put out by the marshals, because those of us who in the know would recognize that a good few months have passed before we get to that point, and you really should have been looking for somewhere to be.
While we don't have a lot of time left, and I guess this is wrap-up time, in a situation, this is on the landlord side, on a situation where tenants have done serious damage to the houses before they move out, what sort of recourse do they have?
That is a separate action. And landlord, the former landlord, should have some idea of where the former tenant has moved to so that they can serve them, because they do have to bring a separate action in relation to the damage done. If there was a proper agreement, there would have been some monies held as security deposit in any event, which can be applied to the repairs to the property.
Never enough time, Verla, but thank you for that perspective on criminal law and, of course, answering all of our questions. We'll have you back next week. Colin, we come to the end of another great show.
We go off with the
image.
Is that Casey?
It is.
Not Casey. What was it? Baby's name?
Kaylee.
All right. Kaylee and her granddad.
Kaylee and her granddad in life. Thanks for joining us. We'll see you tomorrow. Morning, Barbados.
Good morning.